The Law Commission, in legislating the Criminal Code, Offences Against the Person and General Principles, criticized the law on non-fatal offences against the person on three main issues. Firstly, the language used is complicated, obscure and outdated. Secondly, the structure of the offences. And thirdly, the Law Commission was critical of the effectiveness of the current law on non-fatal offences against the person. The Law Commission proposed to repeal sections 18, 20 and 47 and replace them with new provisions. The language used in the Offences Against the Person Act 1861 is no doubt outdated. For example, the words grievous and malicious are not generally used in modern times and have required interpretation by the courts. Grievous has been interpreted as meaning really serious in DPP versus Smith. However, malicious has been given an interpretation quite unrelated to what one might expect. In general parlance, the word malicious is perhaps related to evil or hatred, whereas in legal terms, malicious simply means intentionally or recklessly. There exists further problems with misleading language used. For example, in everyday usage, the word assault generally conjures up an image of physical attack, whereas in legal terms no physical contact is required. The term battery, in general usage, suggests a higher level of force than is actually required by law. The use of the word bodily harm under sections 18, 20 and 47 includes psychiatric harm according to R.V. Ireland, R.V. Burstow and R.V. Constanza. However, it is highly unlikely the Victorian draftsman would have had this type of harm in mind. Use of the word inflict has caused the courts considerable problems. It was first interpreted as requiring proof of an assault or battery in R.V. Clarence. In R.V. Wilson, it was stated all that was required was the direct application of force. However, in R.V. Martin, the defendant was liable where the force was indirectly applied. The current meaning was established in R.V. Burstow as simply meaning cause. The structure of the offences can also be criticized. There is no statutory definition of assault or battery, and there are no clear boundaries between the offences. Any intentional touching of another without consent will amount to a battery following Faulkner v. Talbot, whereas any hurt or injury calculated to interfere with the comfort of the victim amounts to ABH as established in R.V. Miller. There seems little difference between the two, other than interference with comfort, yet battery carries a maximum penalty of 6 months, whereas for ABH it is 5 years. Similarly, there is no clear boundary between ABH and GBH. It is for the jury to decide what amounts to really serious harm, and different juries will differ in their opinions. ABH and GBH can have very different levels of severity of injury, and yet an offence of GBH under Section 20 carries the same maximum penalty as an offence of ABH under Section 47. Yet for GBH, the punishment jumps from 5 years to life for an offence under Section 18, which could involve the same injury as an offence under Section 20. It is illogical to have a separate offence of wounding which is considered alongside GBH. A breaking of the 7 layers of the skin constitutes a wound according to Moriarty v. Brooks. Thus, a pin prick could suffice, which is clearly far removed from really serious harm. A further criticism is the effectiveness of the offences. Many non-fatal offences against the person will go unpunished. Many will not be reported, and many that are reported may not be prosecuted. This has been a particular problem in the past with regards to domestic violence. Furthermore, prosecutors will generally charge under a lesser offence in order to secure a conviction, and plea bargaining is often used. Also, there is a practice in some areas of not prosecuting assault and battery as the costs involved outweigh the benefits. It is not generally seen as being in the public interest to bring a prosecution where no injury is involved. In summary, the main criticisms of non-fatal offences against the person include the misleading and outdated language, the structure of the offences in terms of no clear boundaries between them, and the sentences may not reflect the gravity of the offence, and lastly, the offences are not always enforced. This video is part of a series of videos on law from www. e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.